The first case to come before the court is N. Ray R.R. Each party will have up to 15 minutes to present their arguments. The appellants may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know as I'll be keeping track of the time. And I understand that you all know that you need to split your time accordingly, okay? The arguments are being recorded, so please stay behind the podium, introduce yourselves, keep your voices up. You should not use the names of children or minors or victims during your argument, and you can refer to them by initials or generic terms like the child. The judges have read your briefs and we're ready to proceed when you are. And if you would let me know at this time, would you like to reserve time for rebuttal?
I'll reserve 5 minutes.
Very well. Then you may start when you are ready.
Thank you very much, Your Honor, and the other judges on the court. Please, the court, I am Alan Medvick. I am here representing the mother in this matter, along with Attorney Tom Whitlock, who is here representing the father. I believe I am going to make the arguments on behalf of both parents this morning, and we are here today on one assignment of error, and that is that the trial court erred in finding that the child in this matter was dependent under subsection D of the appropriate statute, and that is a statute that requires that the child be found to be the sibling, residing in the household of children who have been previously adjudicated as abused, neglected, or dependent, and that the conditions of environment in that household are such that the child is likely to be abused or neglected. And it is the position of the parents that that burden has not been met, really in either prong. The facts in this case are that there are older siblings involved in a separate DN case that have been adjudicated, had been at that time adjudicated as abused, neglected, and dependent. It's undisputed that those children were adjudicated such. However, during the pregnancy for this child, the parents moved to Pennsylvania voluntarily. They left the state in order to have this child and to place that child voluntarily in the custody, in the placement of maternal grandparents. Maternal grandparents were prepared to take placement of that child during the pendency of the other children's DN actions and to allow parents to resolve the issues that have brought those other children to the attention of the agency. They made a voluntary decision to do so and were prepared to do so, and in fact attempted to do so. And such voluntary placement is well within a parent's right, and given that the placement was appropriate and all of the needs could be met, it is the holding of Ohio law that appropriate placement on the part of the parents would negate any dependency finding. I would point you to N. Ray Riddle, 79 Ohio State 3rd, 259, that holds exactly that. The parent's voluntary act of temporary placing the child with a responsible relative is an indicator of proper parental care and does not support the finding of fault in the dependency finding. So, in that regard, I would say that there has been an egregious error on the part of the trial court, and that the child should have been returned, should have been placed in the custody of the maternal grandparents. And which brings up the bizarre jurisdictional and procedural aspects of this case. This was a case that started presumably under Pennsylvania law. A child was adjudicated in Berks County, Pennsylvania, and then the case was transferred here and the child placed here. But that case was subsequently dismissed for timing concerns, which would presumably have nullified the finding from Pennsylvania. and yet somehow we then proceeded on custody on a refiled DN case here, which I think raises some jurisdictional issues, which I understand were not briefed at any point in this proceeding. However, as a subject matter jurisdiction, I think that that is something that could be investigated by the court. Sua sponte, I would ask, and I have not done that research, and I openly admit that. It is a thing that is popping into my head at this point. Regarding the agency's argument in brief that the agency could, and the court could find a prospective dependency. I don't think that's ever been in dispute by either myself or Mr. Leff on father's behalf. The subsection D is a prospective statute, just by nature. It is one that holds that it is likely that the child would be dependent or would be found abused or neglected, subject to abuse or neglect. However, the agency did not prove such prospective dependency in this case because the child was never going to be in the home of the parents. They were never going to be in a household. That was not the intent. They were going to be placing that child with the maternal grandparents. And the agency has not established, by clear and convincing evidence, that that was an inappropriate house. There is conversation, and as indicated in the agency's brief, some of the concerns were that the grandparents were not forthright with the Berks County Children's Services about their intent to take children, or that during the pregnancy, mother and father may have been staying in their home. But it is, and this I find a lot in the juvenile court, there's a shift of burden that goes on here inappropriately, where they're asking the parents to prove that the house of the grandparents is appropriate, rather than the burden of the agency, which is to prove that the house is inappropriate in some way by clear and convincing evidence. They want to say that my client's parent did not come forward with financial documents, but he testified as to what his savings were. There's no indication that the house was at risk of foreclosure, that there was any opportunity that the children were going to be displaced in any way or unhoused, or that their needs could not be met by this grandparent. Quite the contrary, my client's parents were willing, able, and looking forward to taking care of this child. And the agency was to inappropriately shift that burden and say that somehow my client has to produce additional documents to prove beyond a preponderance that it's their burden. And it is clearly not. This is akin to a criminal matter where it is the agency's job to prove dependency, not my job to prove that the children are not dependent. And so with that, I think that the agency has failed to meet their burden. I would contend that this was a voluntary placement on the decision on the parts of the parents, and that the burden of the agency has not been met to demonstrate that those grandparents were inappropriate, or that there was any dependency possible under subsection D, both by the fact that the child was not going to live in the household of those prior children, and under subsection B, there was no indication that the subsequent household or any condition or environment would subject those children to abuse or neglect, or make it likely to be so. With that, I would see my time holding up to my point. Thank you.
Thank you, counsel.
As Mr. Medvick indicated, he spoke for both of us today. Thank you.
Then you will have 5 minutes.
Thank you.
Good morning. May it please the court, my name is Rick Braley. I'm appearing on behalf of Summit County Prosecutor Sherry Beth Walsh and the Summit County Children's Services Agency. And I just want to briefly summarize what has already been briefed to this court about our position in this matter. And that is essentially that any sort of voluntary placement had no legal effect in this case. Any purported guardianship document was never entered into the record. There was no legal order that changed the custody of this child under Ohio law, which is controlling 2151.06. The child has the same residence and legal settlement as his parents. These concerns about the grandparents are very well documented in the record. They indicate that they were evasive with the agency in Berks County, with the CSD here. They were not responsive. They lied about the situation about how the parents were living and residing when they were in the state of Pennsylvania. And in light of those concerns, I believe it's appropriate, and it was actually determined by the Berks County Court that they were inappropriate kinship care providers. So in light of that, I don't think that there's any indication that there was going to be a time where this child was going to not have the legal settlement and residence of his parents. With that, I'd ask for any questions or ask you to overrule the assignments there.
How was the decision from the Pennsylvania court, is that entered into the record before us, finding it to be inappropriate?
I'm sorry, I don't know the exact answer to that question. I believe there was discussion about that at the hearing. I'm not sure of the actual.
What do you recollect, the order not submitted, but there was testimony regarding the fact that that was it?
I believe there's transcript citations in the brief we provided about that issue.
If the Pennsylvania court had granted guardianship to the grandparents, would you still be saying the child was independent?
I think if there was a legal order or some sort of thing like that, we may be in a very different position here. If there are any further questions, I ask you to affirm the trial.
Hearing none, we thank you, counsel.
Thank you.
You may
Thank you. In response to that, I would indicate that I don't believe that the real case requires that there be any legal change of custody. There is no requirement that the agency sign off on such a change. That if the best example I can give would be in the case of a single parent who may be serving a time in detention, that person can make a voluntary decision, may be able to sign POAs as appropriate, and do what they need to do without making a legal change of custody or even any, and they can make that placement change without even making such a POA. I think that a parent has that right to, within their rights as a parent,
But what are we to do when a different court rejects that?
and
On a
that,
parent to give some other family member, some other person
That becomes
responsibility.
a
Doesn't the law
massive-
say it goes back to the parents for custody?
it's a massive question in this case, because right now, and I want to be clear, that Berks County got involved because of the open interference of the caseworker, of the ongoing caseworker in the prior case in this matter. That Berks County was contacted by Summit County Children's Services and made aware of this. I don't know that there was any reason for Berks County to be involved in the grandparents' life, frankly. And this becomes a question of why we're here on a Pennsylvania case, decided under Pennsylvania law, and suddenly now it's become an Ohio case based on that decision. And they reached adjudication there prior to my opportunity to say that that was inappropriate under the prior case. Now this child's been transferred to Ohio, and now the child's already in Ohio, so when they refile, we're dealing with the jurisdiction here. Seems like a roadmap for how to change jurisdiction on a child case. But that said, I think right now we don't know what that decision would be out of that other court, because that case was dismissed. And that case, at that point, the parents could have attempted, after that dismissal, the case again, I believe, would have been returned to Pennsylvania, was transferred here after adjudication, but for disposition. And I think if that adjudication was dismissed under Pennsylvania law, why was this not returned to Pennsylvania to be decided? And again, that's a jurisdictional question before the court that I had not briefed. But I think it ties into your question, and that's why I'm restating it. When that court made that decision, and that's the thing, I don't know Pennsylvania, that's why we're left holding the bag on this, in that regard, and I find that deeply frustrating. Especially given that this was accomplished by the interference of Summit County Children's Services, and the contact of the caseworker to Berks County. With that, I would rest upon my question.
both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the